Hello, everybody. This is Advocate Lucinda, your empowerment lawyer. I want to talk to those of you who have expressed some intimidation about responding to the defendant's motions, to the brief, writing a brief, and even constructing the complaint. Let me ask you something. Have you ever baked a cake and you followed the recipe to the T? That cake came out all right, didn't it? Or have you read instructions, let's say to put together a bicycle, and you followed those instructions to the T? That bike came out all right, didn't it? Well, this process works in litigation writing. There is a formula to help keep your writing on track. And that formula is facts plus cause of actions plus prima facie elements equal merit. And that's what we're going to talk about today. So let's get started. You know, and the formula never changes. Whether the writing is concerning a brief, motions, pleadings, and I would even go so far to say anything that the plaintiff pro se respond to, any document that the pro se is writing, I suggest write with the formula in mind. It will keep you on track and on point. So let's break down this formula. Pro se, the facts that you submit that you are relying on to support your case, they must be informative. They must be based in reality. They must be the events that are stated in your complaint. They must have actually occurred. Truthfulness. Your statements must be truthful. And the facts in the case, they should be relevant and material. What am I saying here, pro se? You need to vet your facts. Don't be in your emotions, but vet the facts and nothing but the facts. Okay? Plaintiff, pro se, you must have a cause of action because it is the legal theory upon which you will bring the lawsuit. For example, let's use Title VII, Sex Discrimination and Retaliation. Sex discrimination and retaliation has prima facie elements that the plaintiff must establish in the complaint. In other words, prima facie elements is the standard of proof that a party needs to present sufficient evidence that a given claim is true. In other words, per se, the complaint should house facts to show that you've established the prima facie elements for the cause of action. So, to demonstrate this point, let's use retaliation. So, in order for the plaintiff to establish retaliation, the plaintiff must show that he or she engaged in protected activity. Does the allegations in the complaint cover this? Did the defendant know about the plaintiff's engagement in the protected activity? Are there enumerated allegations in the complaint that makes this clear that this is what the plaintiff is complaining about, basing his or her lawsuit on? Next, The defendant took an adverse action against the plaintiff after learning that the plaintiff engaged in protected activity. Are there enumerated allegations in the complaint that address this? And was there a causal connection? In other words, was there a link between the illegal conduct, and that is the retaliation for the plaintiff complaining, and the adverse action, which is the actual retaliation? For example, termination. And two things that you really want to look at in terms of causal connection: there was no write-ups prior to the adverse action. The plaintiff never had write-ups. That's a strong inference of discrimination and retaliation. And also the employer terminating the employee the next day after the employer learns of the protected activity. Are there facts enumerated in the complaint, pro se, that will help you to establish this causal connection? Do you want to state your facts sufficiently to overcome defendant's motion to dismiss? Now, let me say this. In the case where the defendant files a motion to dismiss, the court accepts all allegations of the complaint as true and construes the facts in the light most favorable to the plaintiff. So here, the plaintiff must establish the prima facie elements to the extent the court believes the case has such merit that it should continue and discovery should be had. Put another way, the court sees plausibility and therefore, in that case, would deny the defendant's motion to dismiss. So your goal is to get the court to see merit in your case. You may have to fight for it, some more than others, but that's your goal. Be on point, stay on point. Follow the formula. I hope this has been helpful to you. I'm Advocate Lucinda, and we'll see you next time. Take care.